Good morning, ladies and gentlemen. We'll start off like I do every time and thanking you again for your service. We've come in for 5 weeks to your community. Everyone's been very nice, hospitable around town. And I know you've all made a major sacrifice, giving up your daily lives to be here with all of us. And on behalf of myself, the other lawyers, and the judge, thank you once more time for your service. And I hope in some level you found it to be perhaps educational to some degree. And what we're going to do here for the next few minutes is try to convince you folks that the proper penalty is not the death penalty, but life in prison with no parole. We believe that is the correct sentence. And I do want to remind the jurors that during jury selection, one of the things that we discussed was that if we got to this point, you would be willing, all of you, to remember, you guys got pared down from 160-something people. All of us believed that you were the fairest ones that we could get to do this trial. And we did talk about this possibility, and that we would certainly give the defense a chance to get that life sentence. Now, I also want to start, Mr. President, remind everyone that the mitigation and the presentation of evidence put forth by the defense in this part of the case was not a defense to any crimes of conviction that you have found with respect to her. It's not an excuse for any criminal activity that you found someone responsible for. That's not what this was about. But what we believe we provided to the jury is a path forward that you could vote for life with no parole, look yourself in the mirror, and feel good about it. And that's what the mitigation is all about. And as I said before, if you are going to be tasked with making a decision as important as whether Toledo should live or die, it only makes sense that you provide him with as much information that we can about him. Many people say, this came out on jury selection, that life in prison with no parole is a harsher sentence than the death penalty. That's not an uncommon thought. And I happen to agree with it. I mean, you have to. But that is a harsh sentence, especially if you're talking someone his age. He's in his mid-30s. And, you know, living in prison is a horrible existence. You're living in a little tiny cage, maybe a few feet to walk in either direction. And he will die in prison as a result of your verdicts. We all know that. Now, what I want to talk to you about here at the beginning are the aggravating factors that the state has argued, put forth as reason to give the death penalty. And in no particular order, the issue of the prior violent felony. I will agree, based on their records, you know, they've proven that fact beyond a reasonable doubt. But the question is, how much weight does the jury assign to it? This was an event in 1999 when Mr. Toledo was 17 years old. He was a juvenile. He got prosecuted as an adult, which under the law is perfectly legal. But the truth of the matter is, he was a kid. It was 1999. He went and did his time, and there was no other prior or no other violence put forth until the case that we're here with. Now, under the law, the way it works is, you know, the incident that night also creates another prior violent felony, but that really was one incident, and they convicted him of those crimes. But this aggravator really is for people who are constantly getting in violent felony type trouble, and that's not what the record is against Mr. Toledo. The state wants you to believe that, but the evidence is in your court here. 1999, 2000. 13. So, although it may be proven beyond a reasonable doubt, I would suggest that the weight for that particular aggravator should be given very minimal weight. Now, the children are under 12 and in the familial custody of Mr. Toledo. Obviously, we're going to concede that. We're going to stand here and try to argue it any other way. They've proven that beyond a reasonable doubt. You can give it the weight that you think is appropriate. In my mind, that would certainly be their main aggravator. But remember this, they list as 5, but 4 and 5 are one together, so it's really 4 as far as aggravators. Now, this other aggravator that they wanted to argue, cold, calculated, premeditated. Well, I don't believe there's any evidence in this case that would support using that aggravating factor as a way to get the death penalty. First of all, the premeditation, that's the charge you convicted him of, premeditated murder. So how does that really add anything? The way it adds something, this is supposed to be for cases like contract killings, long-term pre-planned murders, heightened, what they call heightened premeditation. There is no evidence in this case to support that aggravating factor. It's a theory that the state has put out there, but there's no evidence to support it. And I would suggest that if you did find that aggravating factor, that would also get very little weight. I don't believe, though, that that factor has been proven beyond a reasonable doubt. On behalf of the defense, we ask you not to find that they met their burden in that particular aggravator. And then the killing was to avoid an arrest. Well, I'm going to make the same argument. And let me just say this before I get too deep into this thing. This is not an easy concept to be doing up here, because what we have to do is this mental, intellectual discussion about murder and what type of murder and how was it done and things. And any murder is horrible. Any murder is horrible. But we have to do this exercise to decide, well, exactly how horrible it is. And it does create this feeling like you're separating yourself from your emotions. And that's really what you have to do. And perhaps after the trial, quiet time of reflection, feel how you want. But for this deliberation process, we really need you to get yourself away from any emotional feelings of sympathy, kind of analyze it like you're looking maybe at a book or a problem to solve in a book. It takes that type of analysis. To avoid arrest, there was no evidence of that. Now, that is the state's speculation and their theory, but you're going to be tasked with having to find that this was proven beyond a reasonable doubt. And I would suggest to you, you're going to have a hard time searching for the evidence to prove that. And so, for the one that's the heightened premeditation, the defense position that's not proven beyond a reasonable doubt, same with the killing to avoid arrest, you can see that he did have a prior violent felony, 1999, and that the children were under 12 and in familial custody of Mr. Toledo. And it's also important to remember, though, however many of their 4 that you may decide they've proven, you don't then aggregate or combine for each kid. Each child would have 4, 3, 2, or 1. They don't go 8, 7, or 6. So I just want to make sure everyone understands that. Now, one of the pieces of evidence that was put forth during the penalty phase was what they call victim impact evidence. And this always is very concerning to the defense. And it's troubling that the state is allowed to present this to the jury. It's very compelling testimony and evidence. I would say both those witnesses did an outstanding job and had heartfelt stories to tell. So they give you all that, and then the judge is going to tell you here in a few minutes, don't consider that, though, in any aggravation or use it in any way to support death penalty verdict. And so it's another kind of weird concept, but I'd ask, please urge, and if it gets forgotten somehow, someone remind the rest of the group that although it's extremely compelling testimony, it is not to be used by the jury to come back with the death penalty verdict. Now, I want to discuss at this point some of the doctor testimony. The state gave you their spin on it, so let me tell you how we feel about it. The first doctor we brought up was Dr. Mings, very well respected in the legal community, 30 plus years in the business. Said he's done over 10,000 of these exams that he talked about. He told us that he, in the past, has testified for the defense, but he's also testified for the state, and even more specifically, he got asked to do an evaluation of an inmate that was on death row to see if he was still competent to be executed. And in fact, Dr. Mings, I'm telling you, or my position is a straight shooter, he said yes. And so if the state's contention is he's some type of defense witness, well, that's not true. We have empirical evidence otherwise. And so I would suggest that Dr. Mings was extremely believable. He reviewed the historical records, he reviewed prison medical records, other hospital records. And the testimony is uncontroverted, although the state, of course, has a different take on this, but Lewis was a poor student, and he was in special education classes. He dropped out of school in the 9th grade, and the last 5 grades he had were all Fs. Now, the state says, well, that's because he doesn't try hard. Well, there's no evidence for that. You didn't hear any evidence that he didn't try hard. Dr. Mings talked about his history of suicide, his history of cutting himself, and again, the brain abnormalities. So I guess the state's theory is, since they take this position that Lewis has been lingering all this time, when he tried to kill himself, that must have been fake. When he cut himself because he was in emotional pain, that had to be fake. The suicide attempt in the jailhouse, that's all fake. But we know it's not. You saw the evidence of that suicide attempt, the bloody floor, and all of that. That wasn't anything fake. The man was in major distress at that time, if you remember. He was extremely depressed, and it was a true attempt to kill himself. I guarantee it is. Mr. Ford, Mr. Pagliari, Mr. Sheps didn't take it lightly and think he was malingering or faking that. You saw how panicked they were. They thought perhaps Mr. Toledo was going to die that day. That could not happen while he's in their custody. He has started having seizures at 3 years old. He got admitted to Mount Sinai Psychiatric Hospital for 7 months as a 9-year-old little boy. Now think about that. So I guess when he's 8, 7, almost 9, he's already figured out how he's going to fool all these doctors. He's going to malinger himself into a mental hospital for 7 months. Does that make sense to anyone? A 9-year-old boy faking a mental illness to the point where he's admitted as an inpatient in a mental hospital. They want you to believe he's faking this. He talked about his head injuries, and no one could pinpoint a certain thing. But sometimes records can't be found. That should not be held against the defense of Mr. Toledo. These certain records are not found. He described multiple episodes of having head injuries, the automobile, the hit with the hardball, He has scars on his face and pellets in his head today as he sits there. Dr. Mings told us that he has a test specifically to see if someone's malingering, and he administered it, and Lewis did fine. He said there was no evidence of malingering. Dr. Mings' testimony showed that for years and years he's had problems. Just the list of prescription medicine alone shows you he can't malinger all these things. He was prescribed Remeron, Ricidol, Geodon, Liprexa, Syracuse, Paxil, Wellbutrin, which he's still on today as he sits here. So I guess even the jails in 2013 to now, he's still fooling all these people to get this medicine. Something called valproic acid. These are medical doctors prescribing these prescription drugs to him. So the doctors are all in on this malingering too? Is that what the state wants everyone to believe? You know, there seemed to be some issue with the state's doctor on the way Dr. Mings does neuropsychological testing. Well, he's done it over 10,000 times. You would have known that he certainly knows how to do it. Now, maybe Dr. Meadows has another way to do it. But it doesn't mean that what Dr. Mings did is incorrect. Dr. Mings said it took him over 4 hours to do those tests with Lewis. Dr. Meadows says he spent 2 hours, but 45 minutes of it, he didn't say one word to Lewis because Lewis was taking a test. So he knew him for an hour and 15 minutes. Dr. Mings said his IQ scores have such a rare split that only 2% of the total population have it. Now, Dr. Meadows seems to take issue with that and says he's making it up or he's doing it wrong. Well, I talked to Dr. Mings about that quite a bit, and he was sure as he could possibly be that that was correct, and that is the evidence in front of the jury. The records, the testing, the testimony by Dr. Mings, I would suggest, is uncontroverted. Lewis has had brain problems documented since the age of 3 years old. And I would submit to you that Dr. Mings would not come into this courtroom and intentionally try to mislead this jury. His findings were that he had neurocognitive disorder, bipolar disorder, attention deficit hyperactivity disorder, and it's all backed by his testing. I asked him, I said, is he incompetent? Is he insane? He's like, no, that's not what this is about. I don't suggest him that. But he is, I'm willing to argue, mentally ill. Now, there are many different levels of mental illness. I don't know exactly what his level is, but it just seems unbelievable to think that after all those records and presentation, that you actually come in here as a state doctor and suggest that he has no mental problems. It just doesn't fly in the face of the evidence. Discussed the bipolar issue with Dr. Mings. And he decided, his opinion, based on everything that he knew, that on that time frame, October of 2013, based on a total or a combination of different factors, his opinion, Lewis's capacity to conform his behavior to the constraints of the law was substantially impaired. That's his opinion. You saw him, you can weigh his testimony, but that is his opinion, and he's not going to do that lightly, I suggest. Now, Dr. Wu was brought in after Dr. Mings did his work. There was a feeling there may be some brain issues. We need to get further into this analysis. He's also very experienced, 30 years in the business. His qualifications were amazing. He knew so much about that PET scan, it almost seems like you're talking to the person who invented the machine himself. He testified that these machines are used all the time. Very reliable medical tool. And used for Alzheimer's, tumors, and other things. And so Dr. Holder says, well, yeah, that's true. They are really good for that. But for what you want, they're no good. Because you're the defense. Dr. Wu came here from California to monitor the test to make sure it was done properly. You heard about the radioactive sugar isotopes and all that. Make sure it was done right. He said everything went without a hitch. It's not his machine. It's a machine over here in Rockledge, Florida. On Dr. Wu's PET scan machine. He can't tell the machine what to do. And based on his analysis of those scans, his opinion is his brain is abnormal. You know, the bottom line is, I guess, somehow Lewis is able to telepathically malinger a PET scan. He has the ability to fake results on a machine and then fool a computer software program into pointing out parts on his brain that are abnormal. He has amazing powers, according to the state. You know, you can toss all these doctors' things aside, but the pictures on the images don't lie. And he does a visual analysis, and he doesn't stop there. He has statistical, mathematical formulas that are accepted in his practice, and he uses them. I asked Dr. Holder, did you check the measurements from the, no, I didn't. You know, did you do a mathematical statistical analysis like Dr. Wu? No, I didn't. In fact, I looked at the scan for an hour and then concluded that Dr. Wu is full of baloney. Now, these state doctors are amazing because they can come in here, spend an hour with a person in a room, look at a scan for an hour, and totally blow up the defense presentation. Well, we don't agree. Dr. Wu himself teaches others on how to administer PET scans and how to read them. He has lectured all over the world. So I guess he spends half his time traveling the world trying to fool people that he knows what he's talking about. And he's been doing this for years. As to dismiss his testimony and his work as some type of junk science, and that's quite frankly disrespectful to Dr. Wu and to the defense. He has nothing to gain here. He's retired for 30 years, faculty at the University of California, Irvine. What does he have to possibly gain to come in here and try to pull one over on the court? That's not what it's about. What he does in the end is he has a group of known, normal brains and compares them to the images he gets from the person that referred to him, and through this analysis, he does his testing, coupled with the software, coupled with the statistical analysis. He talked about how the damage to the temporal area of Lewis's brain, one of the black areas, is what is responsible for his seizure disorder. Now that was uncontroverted. Dr. Holder, I don't believe, got into that. He talked about how his frontal lobe damage, another area shown on the scan, was damaged and how it affects people with that damage's behavior. He used the example of a car that doesn't have its brakes working properly. Can't control impulses the correct way. And he said the bottom line is, in his opinion, Lewis's brain is not wired correctly. And that is the bottom line. It revolves around his brain. And I also would suggest the same that I did for Dr. Mings and Dr. Wu, is gentlemen are not going to come in here, risk their entire working career try to perpetrate a fraud.
Yeah, I'm sorry, I'm going to have to object. Second comment, this is improper
I submit to you, these men have worked too hard and too long in their fields. Now, you heard from Dr. Holder. He's going to come in here and look at a scan a little before court and tear apart all the other work that's been done. But he wears a lot of hats. He's not like Dr. Dr. Wu, where that's all he does. This guy works for drug companies, he consults for these other businesses, he's doing this and that. I don't think he's nearly as qualified as Dr. Wu. His sole mission in this case was to come in here and tell you that he looked at that scan and it's normal. And how does he know Dr. Wu is wrong? Because he looked at the scan for an hour before he testified. That's how he knows. Now, Dr. Meadows, the other state doctor, I would suggest to you is not believable at all. He spent 1 hour with Mr. Toledo, another 45 minutes where Mr. Toledo was doing a test. Somehow in that hour, he has solved this mystery and figured out that every other doctor that has said something's wrong with Louis Toledo is wrong. Dr. Wu, Dr. Mings, all the doctors from the prison hospitals, all the doctors when he's a little boy. It's all this big conspiracy. They're all wrong. And I'm Mr. Dr. Meadows, and I'm right. And I know I'm right because I got this book right here, and that shows I'm right. Well, I'm sorry, doctor. You need to do more than that. He takes notes of this during this evaluation, and purposely, or maybe not purposely, but he doesn't write down the notes that relate back good information about Louis, about how he took care of his father when he was dying. Oh, I wrote that one down. You know, come on, doctor, are you playing fair? Or are you going siding here with the state? He's not believable. That's our position. You heard from Dr. Holmes discussing the bipolar issue, that Louis has been diagnosed with this disorder, that he was medicated for the disorder. She talked about the highs and the lows. Well, you saw some of that in the trial. You saw this man having an extremely depressive episode. Not just like she said when you get a little sad. Extreme depression. He had the text messages where you saw some of that high and low. The phone call to Miss Newell, I would suggest to you that for that 45-minute phone call where she maybe said 3 words, he was in a manic state. That was what you heard right there. For that whole 45 minutes, it's Louis in his manic state. Going on and on and on. She couldn't get a word in edgewise. Dr. Holmes talked about the malingering, her take on it. And it doesn't mean, as somebody says that in a report, that you totally fake things. It means also just symptoms being either exaggerated or under-exaggerated. She said, regardless of these malingering diagnoses, there is still all the other evidence that is undeniable. And she told us how people who have that disorder, on occasion, can act aggressively and do violent acts. Now, it is true, I'm not going to suggest here that just because you have bipolar, you're going to act that way, but it's also true that it's possible. There are many, many people that are bipolar, take their medication, and live okay, without any problems. But, common sense, she's right. It doesn't mean that everyone is able to do that who has bipolar, especially if you're not taking your medicine. And the testimony from Dr. Holmes is, in the time frame of October 2013, Louis was not taking his bipolar medicine. Now, I want to discuss what the defense puts forth as the mitigating factors. And before I do, let me just read one instruction here. Unlike aggravating factors, the finding of a mitigating circumstance does not have to be unanimous. Okay, and I know you know this, taught this days, you're going to hear it again, but there is that big distinction. For the aggravators, you all have to agree on the same one. It's not like 12 of you go back there and I find this aggravator, well, I find that one, but not that one. You all have to agree on the same thing. Each juror makes an individual decision, though, as to the mitigating circumstance. And so when you are back there and you're deliberating these mitigators and aggravators, just remember there are different burdens of proof imposed on the state than the defense. Now, I'm going to go through this relatively quick fashion, and I will obviously concede, I don't want to lose credibility here, that some of these are not as strong as others. I mean, they aren't, but they are something to be considered. I mean, we're reaching for straws here, ladies and gentlemen. We're trying to get everything we can to you. The state wants you to kill our client. So, here we go. On the day and the night of the crime, the defendant's mental capacity to perform his behavior, restraints of the law, was substantially impaired. And what we have to do is show some existence of these through the evidence and testimony, and then you are to consider them to be proven. So that came from Dr. Mings. Mr. Toledo spent time as an inpatient child in the psychiatric ward at Mount Sinai Hospital for 7 months. As a 9-year-old, that's from doctors and the records that we've seen from Lincoln. Mr. Toledo was diagnosed with behavioral issues as a child. He attended Walter Van Ross School, special ed school that came from the Lincoln Hospital records. Mr. Toledo suffered the sudden death of his mother, Ada, to a heart attack in 2002. That came from Dr. Meadows. Mr. Toledo is a loving family member, brother, cousin, uncle, that came from Madeline. And I don't know if you noticed, but after Mr. Chris Lasanta had testified for the state, he came back on his brother's behalf and was sitting in the audience. Mr. Toledo has attempted to better his life by attaining GED, enrolling in technical college. That was proven from the interview with Dr. Meadows. Mr. Toledo has a long history of head injuries and concussions. That's from the Lincoln Hospital records. Mr. Toledo has a history of being admitted to the hospital for multiple physical injuries. That one may not, okay, yeah, he fell off his bike and hurt his knee, and he fell another time and hurt his chin. But they may not be the strongest, but they're certainly proven. Mr. Toledo was attending trade school in Barber College to try to better his life. That came from the trial testimony. Mr. Toledo has a history of various employment, including construction, masonry, fast food industry. That's from the trial, but also Dr. Mings, Dr. Meadows. Defendant has and maintains a relationship with his 16-year-old daughter, came from Dr. Meadows. Mr. Toledo was generous with his time, helped a friend when she ran out of gas. That was a story that Robin Roberts told us during the state's case. Mr. Toledo has demonstrated grief and remorse. We've seen that live and in color, unless the state wants to argue that he somehow can fake that grief and remorse. October 26, 2013, Mr. Toledo tried to kill himself. We saw that on tape, trial evidence. Mr. Toledo had an abnormal psychiatric history as a child, the Lincoln Hospital records. The defendant's father, Carlos Toledo, died of ALS at the age of 39. Trial testimony. Mr. Toledo's family lived in public housing in the Bronx. This is from the Lincoln records. Mr. Toledo has the capacity to form loving relationships even while incarcerated. That's from Madeline. Remember, she told you she loved Lewis from way back. She knows what he's been charged and convicted of. She still loves her cousin. She will continue to do so while he's in prison. Mr. Toledo was shot in the head and face. Still has pellets in his head. That's from the hospital records. Mr. Toledo attended church, was religious. The trial evidence. Mr. Toledo demonstrated good behavior at trial, and that's just an observation. Mr. Toledo had a good relationship with his parents. That came out from the Lincoln Hospital records. Mr. Toledo has been emotionally unstable since he was a young child. It's also from the hospital records. According to his educational records, Mr. Toledo had a poor school record and was required to attend those special classes. Remember his grades, all the F's, dropping out. It's the next one. Mr. Toledo dropped out in the 9th grade. Dr. Mings. Mr. Toledo was a caregiver for his ill and dying father, Dr. Meadows. The defendant has a history of cutting himself, Dr. Mings. Mr. Toledo's mother died while he was incarcerated. I know I said that earlier, but there was further testimony that happened while he was in prison, and he was not able to grieve properly for her. Dr. Meadows. Mr. Toledo was involved in a car accident in the year 2000, which rendered him unconscious and in the hospital for many days. Dr. Mings. Mr. Toledo has a very rare IQ score, leaving him in the bottom 2% of the general population. It's Dr. Mings. Mr. Toledo has a defective frontal lobe, which affects his impulse control. Dr. Wu. Mr. Toledo has a defective temporal lobe, which produces seizures. Dr. Wu. Mr. Toledo has had grand mal seizures since the age of 9. Actually, typo should be 3. But those are from the Lincoln Hospital records. Mr. Toledo has shown early signs of ALS, the same disease his father died from at the age of 39. He has loss of muscle control and the other things that we had talked about. Mr. Toledo has bipolar disorder. That's Mings, Wu, Holmes. And Mr. Toledo has a seizure disorder, also from the hospital and Dr. Wu. So, what you're going to do, you'll have a list of all those with your verdict form, and you're going to be asked to go through the list and see if there's in some existence of those proven, and if they are, then they are to be accepted. Now, you still have to do your weighing process, but as long as there's some existence, you can check the box that shows they have been established. Another instruction I wanted to read. This is within the longer version of all these. Any juror individually persuaded as to the existence of a mitigating circumstance must consider it in the case. Further, any juror individually may consider a mitigating circumstance found by another juror, even if she or he did not find it themselves. So obviously there is a requirement for the second phase for some deliberation, but we've talked about this a little bit in jury selection, and it is different, I'm going to argue, than the first phase, where you're tasked to go back and you all have to agree to the same verdict. That's not the way it is here, and I don't believe it requires as intense deliberation either. If you've fairly thought it through, and in your opinion, the aggravation does not outweigh the mitigation, then you can pretty much stop, your part of the deliberation, let others who are still talking talk about it. But if that's the way it goes, I am asking you, on behalf of Mr. Toledo and the defense, please hold on to that vote and don't let it go away. An older, much wiser lawyer than me once said that the highest calling any lawyer can have is to be willing to take on the state, to fight, to try to save someone's life. And I believe that to be true. Mr. Toledo is not an abstraction or an abstract figure. He's a living, breathing human being. And premeditated murder in the name of the state is an outrage.
That's completely improper statement. I ask that the, and I ask that the jury disregard the comment.
Please disregard the Please rephrase your comments.
Well, here's what happens, ladies and gentlemen, when you find yourself in the position of Mr. Toledo. It all starts with an invitation. Notice of intent to seek the death penalty. You get one of those in the mail, that'll make your heart skip a beat. But that's how it starts. And then the state gets the ball rolling and does everything they can to try to get this death penalty.
This is completely inappropriate argument.
They bring in witnesses to support that request. They bring in doctors to support that request. But because we're in a courtroom and not out on the street, it's clean, antiseptic.
We approach. Yes.
I would say it's fair to suggest that there's been a lot of time and effort invested by the state to ask you for a penalty. And the defense doesn't think that's right. We don't like the death penalty at all. I suggest to you that there are many, many reasons that you could give Louis Toledo the sentence of life in prison with no parole. And there's only one reason to give him the death penalty. Now, the reasons I'm going to suggest for the life with no parole are as follows. All the mitigating factors we've heard, all the medical records we've seen, all the mental health records we've seen, clearly have someone with an abnormal brain. Documented seizures starting at 3 years old. And it's not just me saying his brain's not normal. That's documented. The doctors have told you the difference between people like Louis Toledo and others is an inability under certain major stressful situations to not be able to control an impulsive thought. And so, and there are many circumstances in our daily lives we may get angry, but people with his type of brain problems have a much more difficult time dealing with those situations. More reasons for life with no parole. It puts an end to the years of death penalty appeals. We know he'll still die in prison. He's going to come out in a pine box. I'm going to empty the tool chest here. What do we have to lose? Think of it like this. Louis has been trying to kill himself for years. So if you're on the jury, you're thinking about give him what he wants. Don't do that. Make him spend his life in prison. The death penalty to the defense doesn't make sense. We're going to teach you, Mr. Toledo, that you were wrong for killing your family. And you know how we're going to teach you? We're going to kill you. You don't do that with a child or try to teach. A child steals a piece of candy from a convenience store. You're the parent, you find out. You don't teach that child that's wrong by taking his or her candy. Doesn't make sense. He was in a psychiatric hospital for 7 months at 9 years old. Now, as far as the one reason that I would argue for the death penalty, that's what you wanted to do. And before I say this, I do say this with all due respect to the family. But really, the only reason for the death penalty is retribution. It doesn't solve anything. It doesn't deter anything. There's no evidence that death penalty deters crime. It's just retribution for the family. It's not going to solve anything to kill him. The state wants you to believe that he's a dangerous man walking the streets. So we need to eliminate him. You know, I don't think that's what the evidence of the trial showed. I'd say it actually showed the opposite, that Lewis was a good man, and he was trying to be a family man and trying to do well. And the truth of the matter is, from the reading of those texts, we know that Miss Flores knew her husband's history. She had mentioned it in there. You're acting like you street. Okay, so, you know, this whole case is just crazy in so many regards. In our opinion, the life in prison with no parole is the proper sentence. As I said earlier, if you are of that light, please just hold on to that vote, that verdict, and just go with it. Think of Lewis as a little bird, and you're holding him in your hand. And you know what he's been convicted of.
Can we approach him now?
And go with the life